Former Singaporean Transport Minister S. Iswaran faced the High Court on Friday, July 5, seeking a significant procedural move in his legal battle, the disclosure of all witness statements intended for his trial. This marks the second attempt by Iswaran's legal team, led by the highly regarded senior counsel Davinder Singh, to obtain these statements through a criminal revision. Their first attempt in June was not successful, conducted in a closed hearing. The prosecution, represented by Deputy Attorney General Tai Wei-shiong, strongly objected to the defense's request, pointing out inconsistencies in their stance. This objection comes amidst a backdrop of complex legal maneuvers and intense scrutiny from the media and public. S. Iswaran, who is 62 years old, faces a daunting array of 35 charges. These include 32 counts of accepting valuables in his capacity as a public servant, 2 counts of corruption, and 1 count of obstructing justice. The charges are linked to his interactions with notable figures such as property tycoon Ong Beng Sing and Lum Kok Sung, the managing director of Lum Chong Holdings. The nature of these charges suggests a deep and intricate web of alleged corruption and misconduct. Senior counsel Davinder Singh argued passionately for the consolidation of all charges into a single trial rather than having separate proceedings. This strategy, he suggested, would allow for a more comprehensive and coherent defense. Singh contended that Iswaran regarded Ong and Lum as close friends and was genuinely unaware that the gifts he received constituted veiled gratification. Since being formally charged in January, Iswaran has steadfastly maintained his plea of not guilty. He has consistently sought a trial, aiming to clear his name and address the allegations head-on. During the hearing, Singh emphasized the critical importance of pretrial discovery for the defense to prepare adequately. He spent several hours pressing Justice Vincent Hung to order the prosecution to disclose all witness statements under Section 214(1)(d) of the Criminal Procedure Code. Singh argued that the whole point of pretrial discovery is to allow the defense to respond effectively and to enable the court to understand the key issues in the case. Without access to these statements, he contended, the defense would be severely handicapped. Singh also raised serious concerns about what he described as procedural irregularities by the prosecution, which he argued could prejudice Iswaran's defense. He questioned the prosecution's motivations, suggesting that his client was being unfairly singled out. "Why is the prosecution doing this?" he asked. "Why is my client being singled out? And with the effect that he would be discriminated against, by him being refused what everybody else gets?" Singh highlighted a specific incident where the prosecution changed the sequence of the cases involving Ong and Lum, suggesting this was done strategically to disadvantage Iswaran. Initially, Iswaran was charged with offenses involving Ong. However, when the parties were discussing timelines, the prosecution decided to delay Ong's case and start with Lum's case instead. In response, senior counsel Tai Wei-shiong rebutted Singh's claims robustly. Tai accused Singh of misrepresenting the prosecution's statements during his submission. "This is unfair. I do not accept more than half of what he said. He's been paraphrasing or totally mischaracterizing what we said," Tai stated. S. Iswaran resigned from his government positions 2 days before his initial court appearance, following an investigation by the Corrupt Practices Investigation Bureau, CPIB. His resignation marked a significant fall from grace for a once prominent political figure. If convicted of obtaining valuables as a public servant, Iswaran faces up to 2 years in jail, a fine, or both. If found guilty of corruptly obtaining gratification under the Prevention of Corruption Act, he could be jailed for up to 7 years, fined up to 100,000 Singapore dollars, or both. Additionally, obstructing justice carries a potential penalty of up to 7 years in jail, a fine, or both. The case is set for a third criminal case disclosure conference on July 9, following which a trial date will be established. This upcoming conference will be crucial in determining the direction and timeline of the trial. In a related context, it's worth noting that in March 2021, the Online Citizen, TOC, editor Terry Su and contributor Daniel Da Costa failed in their bid to obtain recorded police statements for their ongoing criminal defamation trial. Chief Justice Sundaresh Menon dismissed their applications on procedural and jurisdictional grounds. He agreed with the prosecution that the applications were procedurally defective and constituted non-appealable interlocutory appeals. The Chief Justice noted that the statements were part of unused material that the prosecution might need to disclose but concluded that the obligation was not triggered since the statements were not shown to assist the defense or weaken the prosecution's case. Mr. Su and DaCosta had taken their case to the High Court after 2 district judges dismissed their initial applications. They faced trial over an email letter by DaCosta that allegedly defamed cabinet members and was published by TOC. Thank you for watching this in-depth coverage on 2230. We appreciate your support and encourage you to share your thoughts in the comments below. Don't forget to like, share, and subscribe for more detailed news coverage and updates.